Hi, Mahak. How are you?
Hello, Ankit sir. I'm good. How are you?
Very well. Great to connect finally in person. Of course, I mean, these days in person means virtually like this, but good to the name and to be having this interaction today. Thanks so much for having me.
Thank you so much, sir, for being a guest here. I'm very glad to be hosting you on the theme artificial intelligence and intellectual property rights. So you have beautifully led your law firm Sahni and Associates, a boutique law firm which focuses on intellectual property rights, innovation, and technology. And you have been retained by various Fortune 500 companies for your expertise in IP enforcement and litigation. And so you're probably, I think when I say this, you're probably the only person in the world right now to hold a copyright co-authorship within AI, right?
Possibly, yes.
Yeah. So thank you so much, sir, for leading our discussion today. So before getting engrossed into the discussion, let's set a baseline for the audience.
Mhm.
You commissioned an artificial intelligence app, which is called Raghav, which is short for Robust Artificially Intelligent and Art Visualizer. And you created, the app created a painting based on a photograph that you took and the painting style of Vincent Van Gogh for the Starry Night. Right, sir?
Correct. Mhm.
Yes. And so post that you indulged in certain legal tests and those legal tests in various jurisdictions have different outcomes. So why don't we start with you telling us the current status of some of those legal tests and what your objective was?
Sure. Thanks so much for setting the background. So, Meg, as we discussed earlier in our interactions before, the idea of doing this test case was really to explore how corporate offices, IP offices, other stakeholders in the government, like law ministries
Yeah.
and standing committees, etc., how would various stakeholders in various governments across the world react to a proposition like this. Because as a practitioner, what I started to realize was with the increase in uh, the kind of technology the industry is embracing and using,
Yes.
any kind of industry, not just, say, for instance, entertainment and media, or what Raghav does, the creative, whether it's manufacturing or it's logistics or it's, something that we use on a day to day basis. In fact, many things that we use on a day to day basis, like Uber or
Yes.
Amazon or Zomato or so many different applications, each company, sector, industry has embraced artificial intelligence to a different degree, to a different extent, but it is very much a part of our daily lives.
Yes.
Without, in most cases, without us realizing it, because it happens at the back largely, right? So, if you look at the entertainment and media industry, music producers have for several years now, as I understand, been using artificial intelligence to create loops, beats,
Yes.
rhythms, and so on. And it's the same rhythms, beats, loops that find their way into songs that become popular. Whether it's a background score in a movie or it is the beat or a music to a song, a popular song, a lot of it is being produced with the assistance of artificial intelligence. So that got us to the point where, in our interactions with our clients, what we realized was there is now an extensive use of AI. Of course, AI to the point that it's reached at the moment. There is only a limit to which AI can really be called intelligent, right?
Yeah.
But I feel it's futile, at least for the purpose of today's discussion, to get into whether on nomenclature terms, whether it should be called artificial intelligence, it isn't intelligent, it isn't sentient, and
Yeah.
so on. I think the question is, if a human being relies on technology to such a large or substantive extent that if it were not for the presence of that technology or the assistance of that technology, a particular human being who's creating something would not even have created 10% of what he ends up creating. That is the question that we wanted to ask ourselves first, and then discuss with our clients, and then take this to stakeholders. So the easiest way was to have a test case, but then to have a test case, we needed to have some kind of application that would produce the output that we intended to produce. So what we did was, this was something that my wife and I, purely out of our own funds, decided to bootstrap. We approached a bunch of really clever young computer engineers and AI scientists from India who were pursuing their masters from the Mila Institute in Canada, who then agreed to develop Raghav for us as a project. And once it was developed, trained on a certain data set, and it eventually reached a point where it had all the features and everything that we wanted, is when the title of the program got transferred to us. And that's when we started experimenting and playing around with its capabilities. So as you correctly pointed out at the beginning of this conversation, what Raghav really does, or rather what we thought could be a good test case, a very simple one, where we won't have to complicate the facts of the output won't be something that a common person doesn't or is unable to comprehend. So we wanted to essentially have this example where, in the case of artistic works, we give it two inputs. Style input, which the application is able to learn. So whether it is a Vincent van Gogh, which we used in this case, or it is a Picasso, or it is a Michelangelo, or it is a M.F. Hussain, whatever it is, that an artist is known to put into his or her pieces of art. And the content image is what you want to give. It could be a portrait that you did, a sketch. In our case, it was just a picture that I clicked using my phone's camera of the sunset on that particular day when it was clicked. And then we basically tried to make the application borrow the style of Vincent van Gogh's Starry Night and reimagine the sunset photograph that we gave it in terms of input content. So what the application does is, it obviously, in terms of the human being's discretion, you're able to decide what style you wanted to learn or develop from. You can obviously choose what image goes into the content part of it. You can also play around and basically decide the value or the intensity of how much style would get transferred from the style image to the content image. And then when you're satisfied with what you have, you click on generate, and then it generates the image, all in a matter of less than a minute, basically. So the question came in that photograph, or the output rather, of what Raghav produced. And we decided to call it Suryast, which is the Hindi term for sunset, to put it very simply. And then the first question that we asked ourselves was, if we didn't have this technology, would we have, or would I have, as an individual, come even 10% close to producing this result? The answer, as far as I'm concerned, was a very simple and straight no, because I am speaking of my artistic talents. If you were to give me a pencil and a sheet of paper, I would probably not even be able to draw straight lines, on that. So I could definitely not produce that. So from that emerges a very important legal debate, and one which isn't merely academic, it's very, very practical. Like I mentioned, and during our conversation, I'll try to specifically make reference to some clients without, of course, disclosing on air what companies I'm talking about, but prominent business. And we'll try to discuss them as an example as to what really is happening in their industry. And therefore, why, with the use of AI, all these questions become very relevant. So the first question was the purpose of copyright law since the very early years of when copyright law came into existence, its earliest form, probably the late 1700s, some people would say mid 1800s, and so on, was always that there should be a law that protects the efforts and the creative and artistic ability of a human being. So it started off with paintings, artistic works, and literary works, and then it went on to dramatical works, then musical works, and so on.
Yeah.
So the idea was that if somebody possesses certain talent and is able to produce something which is original and is creative to some extent, of course, we've had now over the past century or so, diverse courts in different jurisdictions taking a different view on, and even countries for that matter in their legislations taking a different policy view on whether creativity is required or not, what degree of creativity are we talking about, sweat of the brow, on one end of the spectrum, and so on and so forth, right? So we won't go into more details on that, but the idea is it has always been to protect human inputs, effort, originality. Now, using a computer, resorting to the assistance of technology to a substantive extent, to such a substantive extent that the output that it generates is merely something that should be credited to the technology, and probably say 10-20% of it to the human being, as far as discretion goes, or as far as providing the input picture goes. And if the input picture is original, then any originality in the input picture, input content, which forms part of what gets modified eventually, right? So aside from that, the end result is substantively different from what the human puts in, right?
Yes.
So why should the human be entitled to take entire credit for this? Would it not be fair to the Michelangelos of today, or the M.F. Hussains of today, or Raja Ravi Vermas of today, when I start using technology and start submitting my entries, which have been generated with the assistance of artificial intelligence, in art competitions, right? And then I end up being victorious, but I should not be credited with having created that painting, because I know I am probably not talented enough to have done that without extensive use and dependence on technology, right? So in that context, the idea was to raise the question as to whether there should be an attribution of, in these works, of a human being having taken the assistance of artificial intelligence. So it started off with that. And then it went one step further, and we said, since we are testing it out, might as well raise the question of making it a co-author. So the idea of making, at least in our case, the idea of making or nominating the artificial intelligence as a co-author was not so much because we believe that artificial intelligence has developed or is entitled to, at least at this stage, any kind of personality rights. I think that isn't the intention at all. We've had all kinds of rather funny, at least to me, rather funny feedback and comments and views that people have shared. Till an artificial intelligence, an AI doesn't start walking, and doesn't sit on a podium and stand at a podium or sit at a desk and start addressing a press conference. We can't call it sentient. It isn't to, personality rights. Who will be the owner? Can it exercise discretion, choice? That wasn't the intention. So we'll keep that debate separate, but I wanted to clarify on air. In most legal systems, wherever we find, in the first bunch, the first lot of jurisdictions we filed in the Indian Corporate Office, the US Corporate Office, and the Canadian IP Office. In each of these countries, there wasn't any other column where you could really indicate or be able to explain and argue why you're wanting to nominate or have them attribute this authorship or the credit of having created something of an artistic work or whatever, say literary work, to an AI. There was no column, separate column or place. So we had no option but to put it in the co-author
Co-authors,
column.
yeah.
And then raise that question and see, look, it's still an experiment. If they refuse, their statutory authorities, they ought to pass a speaking order and explain why they think an AI cannot be an author, right?
Yeah.
So that itself would spark off a debate. With that hope, at least, is why we and how we ended up filing applications. That itself would spark a debate, and we would at least get something out of these bodies, these authorities, regulators, on what they think could be the reason why or why not an AI should be allowed to be identified as a co-author in a statute. So this was the background to this. As far as the current situation goes, we received a registration from the Indian Copyright Act, the Indian Copyright Office. I had an opportunity to basically...
And Canada also.
And Canada as well.
Yeah.
The distinction being that Canada doesn't do a substantive examination. They only do a formal examination of applications. But as I understand, a formal examination of applications does entail that they go through and check all the basic details, records that an applicant has filed. And Raghav artificial intelligence application was very prominently identified, mentioned on the application, the form itself.
Yes.
And even though there wasn't any substantive examination, but there was a formal examination, as I presume there is in all cases, all matters, all corporate applications that go before the Canadian IP Office. Eventually, they decided to grant it registration and allow for Raghav's name to be identified as a co-author besides the human author, which was me. With the Indian Corporate Office, that was actually the first office globally to have passed an order recognizing the Raghav artificial intelligence application as a co-author. And then subsequently, several months later, in fact, nearly a year later, we got a registration in November 2020. And in November 2021 or December 2021, we received a show cause notice saying we will revoke this because we would like you to explain how the current framework of the corporate law permits for such registration to happen where we can nominate or allow an artificial intelligence to be nominated as a co-author. So, of course, we've submitted our legal arguments and we're awaiting a show cause hearing in that matter. So far, they haven't taken any decision on it. There hasn't been any hearing. If you're aware, I'm sure you're aware, under the Indian Corporate Act, the Registrar of Copyrights doesn't have the power to cancel or revoke a registration. For that, they have to file a cancellation before the High Court, which also they haven't done till date. So as of the moment, that registration stands valid. So does the Canadian one. And some interesting background to the Indian side of the story I'd like to also mention is that a year before the notice of revocation came, I was invited by the Indian Parliamentary Standing Committee on Commerce to come and express my views on various issues. Of course, the submissions were very broad-based, and they weren't limited to or focused only on emerging technology or on how artificial intelligence is to be treated. But yes, that was one of the core issues that the committee wanted to hear the experts about. And so three of us, when we deposed before the standing committee. This was one of the questions where they extensively focused and asked us what our views were and so on, and then subsequently were invited to provide further written submissions in support of what we had deposed. So what came out after 6 months to 7 months after the standing committee's meeting at Sansad Bhavan in December 2020, July 2021, they came out with a recommendation report, historical one. Of course, there have been a fair number of people who have criticized the report. That is always the case whenever something comes out. There are a set of stakeholders who will appreciate things, recommendations that are there. There will always be a set of stakeholders who would not appreciate what is or not agree with what is written in these kind of documents and reports. But factually, one of the recommendations that came out was about how, if India is to emerge as a global superpower, focusing on technology, become a technology giant, we need to amend our IP laws, specifically the corporate law, the patents law, to provide for how AI-generated inventions, AI-generated content is going to be treated. And that basically came out as a recommendation, naturally, because we've got a law which was enacted for each of these statutes, which was enacted several decades ago and has basically not been amended as many times as one would have liked, at least not enough number of times to have caught up with how fast technology is evolving. So the last time it got amended was 2012. We are in 2022. And 10 years, the world has changed, not just speaking of technology, but speaking of how people do business, how the world does business, how industry, there's so many new industries or sectors or subcategories of products, offerings that have evolved, which weren't present or nobody could have conceived of them 10 years ago. So the law obviously needs to adapt very quickly to address the challenges that come with such advancements in technology. So this is the background to it. And since then, of course, it has been either bouquets or brickbats, but we very warmly welcome both sets of feedbacks, comments, criticisms, everything, because with everything that I receive in my inbox or every call that I get, I always end up learning a new perspective to how things can be looked at, and what we feel if the law was to be amended and to be made a certain way, what would be the problems that would come with it. And then your mind starts thinking that, how do I take care of that issue that is getting created? Should we then go back to the drawing board? Should the law be amended? Or should the provisions, say something else? How do we take? So it's a great learning experience. And past couple of years, I've had some very, very interesting conversations on this topic with people who are very, very brilliant. And what I can say is I haven't really done much except for perhaps sparking the debate. That too, alongside my colleague Ryan Abbott, who was the original, the OG guy behind AI and AI's prominence. Of course, there are certain differences, subtle but very, very clear and very specific differences between what position their legal tests are basically trying to fight for or bat for versus what we're doing. They're basically in all of their cases.
So there is now a similarity, they are also fighting a case.
Yes, I know. So interestingly, we've been appointed as counsel to represent Dabas in their copyright matter before the corporate office. So we've made that filing. It's public. You can look it up. It's pending. Invariably, the most essential difference has been that they've always had AI as the sole inventor or the sole author, and we've always had AI as a co-author alongside a human being.
So you filed
I think both. Yes, in India we filed 3 applications, and the ones that had the artificial intelligence as the sole uh, author were outrightly refused, for the reasons that obviously are best known to all of us. And but we did file that. But in all of the other jurisdictions and in the jurisdictions to follow, where we're going to take this in file, we're basically going on the debate of whether an AI should get attributed, and whether eventually should it lead to countries, governments recognizing that in their copyright laws, there should be a separate category of rights created for works that have been generated with the assistance of AI, right?
Yeah, like a sui generis system of protection.
Correct, like a sui generis system. And should it be lesser in terms of its scope of protection? Should it be for a shorter duration of time? Should it have more exceptions to its use as opposed to original works that have been created by a human being, and so on, right? So those are some of the debates which we intended to spark off. And fortunately, I think at this stage where we are at in 2022 September, I do believe a number of governments have taken up this very important issue, have either had very highest levels of policy and governance, governance level bodies look into it, whether it's the Indian Parliamentary Standing Committee in India's context, or it's the Canadian Parliamentary Standing Committee, or it's the UK IP office running a consultation. Then, of course, the Canadian Standing Committee report that came out in 2019 followed a consultation that was run by Canadian IP office till November, from June 2021 till November 2021. So a lot of countries are taking up this debate and deciding on what is to be done, with this, and whether there's an amendment needed or not.
But sir, how will India now, progress with this? Do you think it will, the co-authorship will now be like a rule, or it was just an exception? I think you should file more applications now to see what the reaction is.
Definitely. No, I think probably filing more applications may not really serve the purpose. What is important now is, now that the question has been raised and an application, a matter has come before them, they need to adjudicate that matter. Have some kind of finality as far as their policy on this issue goes. And then consequent to that, also decide if they would like to amend their laws to perhaps, for instance, clarify if AI-generated works are required to be protected, and if they are protected, whether they'd be protected for a lesser duration, whether they'd be protected for the same duration, same right, whatever, or introduce a new sui generis system, as you mentioned, whatever the case is. But I think that needs to be done very quickly. And that brings me to a couple of examples that I wanted to share with you. Yes. One very important example is of a logistics company, probably one of the most prominent ones in the world, but of course I won't take names on this conversation, which we advise and represent in India. So they're an autonomous logistics company, and the AI-powered autonomous logistics solutions company. And what they do is they retrofit vehicles with their technology that allows the vehicles to traverse through cities, through highways, through streets without human intervention, right? Okay. So this particular client of ours focuses on commercial side of its application, as opposed to what Tesla and other companies do for largely passenger side of, private, non-commercial kind of. Our client focuses more on freight and large-scale movement of goods from one part of the country to the other on an expressway. So one of the questions that comes up is that, now look, today, how is data getting generated? How is the AI learning, or how is it being able to perform uh, its functions, and how is it being able to do what it's supposed to do. Is that initially when it started off, they probably had human drivers who were driving, and then the sensors in the vehicle were sensing and learning from how a human being would react if they come to a particular cross. If a cow comes, which is very usual for our part of the world, countries in the Indian subcontinent, you're driving on the expressway and suddenly a cow hops over, or whatever, something comes in. So how would a vehicle that's driving, a large commercial vehicle that's driving at speeds of say 100, 80, 90 on an expressway, how would a driver react? So they trained their vehicles and the system on how a driver would drive, how many times would it brake, say what would be the average distance ahead of the hurdle or the object which is in front of the driver. At what distance will the driver instinctively think that brakes need to be applied? On what occasions did the driver actually end up hitting that object, right? And then therefore, what should have been the correct distance for the driver to apply a brake, right? When you're passing through a city, you're passing through a school zone, what is the speed?
Slow down.
Right? You have to stop at the stop sign or the zebra crossing, all of those behavioral patterns, etc., to then pick up and learn what the best and the safest driving style would be, while ensuring, not just safety, but also ensuring that that style of driving is efficient from a fuel consumption perspective, from a time perspective, etc. So then it transitioned to the point where drivers would sit passively and only intervene where they thought that the AI was not going to perform the right or take the right decision, apply brakes at the right point in time. It's accelerating too much, whatever. That was phase 2 of the training. Phase 3 is when the AIs got trained to such an extent that the vehicles are driving autonomously. And in most cases, for legal reasons, there's a driver sitting, but the driver does not have to intervene at all, and is basically just self-driving. And is driving. It can drive for almost 20, 24 hours a day non-stop, depending on how large a gas tank it has before it runs out of fuel, because there's no lethargy, right? It's a machine and it can keep running. So there's so many advantages, so many things, benefits that technology gets you, regardless of what field it is used in. Now, this is one real life use case of AI. Imagine if this company was in India, all right? What is the core of its innovation, or its its secret sauce is really all the data that, say, if the company has some 100 trucks running across different highways in India, each truck is fitted with some 20-22 sensors. So in real time, all the sensors are collecting their own respective data that in real time is getting processed and then sent back to the AI system, which is hosted in the cloud. This is one truck. 100 different trucks are doing that. And from the change in weather conditions, traffic conditions, and so on and so forth, the system that is driving the truck is in real time learning and adapting itself to what changes are happening outside. And it learns from its peers. So one truck is learning from how the 99 other trucks are driving on the same route, say Delhi to Jaipur, right? If there are 100 trucks at different points in time, the other trucks are learning from the 99, one truck is learning from the other 99 trucks that are, hypothetically say, that are collecting data and doing that. Now this data, for instance, you'd see many examples. There are so many of these companies now. One such example is Waymo. Waymo is a company that Google eventually acquired that does autonomous taxis in the US, right? It's completely driverless. It's pretty insane. You just pick up your phone, call the cab, and it reaches and there's no driver inside. So how all of these companies, these businesses are processing data is, if you look at of course, there are different data sets and not everything is human readable, right? But a lot of things are human readable and can be visualized. So for instance, all the obstacles, static obstacles, moving obstacles, objects that are there on a highway, all of that data is being plotted in real time by a truck that passes through a particular intersection on a GPS map. So if there is a human being that is watching it, monitoring the truck remotely, sitting somewhere in a control room or in their office, etc., they're able to see what data the machine is plotting on a map. Now you see that data, how do you protect it under intellectual property rights? That data, if you were to talk about what statute it would fit under, that data is basically, say, a literary work or a artistic work or a combination of literary and artistic works, and therefore has to be protected under copyright. So if somebody technically steals that data, I can sue for breach of confidentiality. There is a confidentiality agreement, or such an arrangement between me and the person that stole it. So that will be under contract law. I can sue under law of tort, but I can also sue under Copyright Act, right? Which is the specialized statute that would deal with literary works or artistic works, etc. Right? Even if it's lines of code, even if it is parameters pertaining to brake velocity, rate of acceleration, blah, blah, blah. It is getting stored somewhere, and that data is subject matter of protection of copyright law, for instance, right? Now,
Yes,
this
sir.
is data which is 100% being generated by an AI without any assistance, intervention, or even a prompt by a human being. How would you protect the interests of businesses that are investing in these kind of technologies? How would you protect the interests of these businesses? Let's take another example of a very famous.
But sir, don't you think India already does that? For computer generated works, they do give protection.
Correct. So great question. So what happens is, uh, assuming it is something which the computer is generated, there is still a requirement. So how do we derive the computer generated concept? Basically, there isn't any express provision, unlike how it is in the UK. There isn't any express provision under the Indian Copyright Act that really says that computer generated works will be. This is something which we imply from the amendment that was made in section 2D, clause 6, when it said author of a computer generated work would be the person that causes the work to be generated,
created,
right? So the question is, from there we are implying, one, Indian law perhaps needs to be clarified. There needs to be an amendment that brings in an express provision that states computer generated works shall be registrable or registered as copyright under the following categories: literary, dramatical, musical, artistic. You also want to include cinematograph films, mention that. You want to include by policy sound recordings, mention that, right? So this is basically how it will perhaps need to be.
But I think that's an umbrella. The computer generated works is like an umbrella term to protect like all things that come.
Correct, but it should be expressly mentioned somewhere, right? Today, as the statute stands, this amendment that came in 1994 was made effective in 95. Although it was inspired by the development under UK law, which happened in the late 80s, and then they brought it here in India, and they said, okay, now UK has also amended its law. Let us also look at revisiting our law, because UK expressly recognizes computer generated works. So India, instead of clarifying it to that extent, simply amended this provision and said for any computer generated works, author will be person who causes. So now that brings us to the question that you asked us. One, we feel, I'm of the personal opinion, the law needs to still be it needs to be clarified, or an amendment needs to be brought in to expressly provide for such works to be protected, not impliedly by amending the definition of an author and not having any substantive.
It has
which,
actually created a lot of ambiguity also, sir, in
correct,
certain terms, like
correct.
causing, like person who causes the work to be, this term causes the work to be created are
Also,
also very
exactly.
ambiguous.
Then to your question, in the case of the example that I took, and it's a real life example, who would you think the person would be? Would it be the person who's supervising the driving and decided to intervene at different points in time, or passively sit and omit to intervene, exercise that discretion? Would it be the driver? Would it be the guy who programmed it? Would it be the people who were driving it when the application was at the training stage? How would you identify the
So we
author of
also
this
have
work?
the
Because it's a
the
vast.
person who finances. We also have this thing, the person who finances in certain situations when there is like
Correct. So,
ambiguity.
correct. So that could be one way of looking at it, but is it necessarily a just way of crediting somebody just because somebody is able to finance and produce something, as is the case with, uh, with sound recordings, for instance, when we look at the definition
Yes,
of, who gets to
films
be the
also.
first owner, then it's the producer in films as well, for instance, right? But is it in the context of this kind of data or these kind of works? Will it be just for the person who's financed to do it? Is the ultimate objective of Copyright Act not, is it not to protect human creativity, human talent, and human effort? If that is the objective, then perhaps one way to argue and say is it could be the person that programmed it, or another person
Yeah.
would say that programming the framework, the structure was not something big. What really brought value into it was the data set on which it was trained. So should it not be the people who trained because they were the ones
Yeah.
driving? So all these different questions are what a government needs to really understand first, appreciate the issues that have arisen because of the advent of technology, and then decide on a policy and then bring the necessary legislative amendments to correct the law or clarify the law. So that is what is required, and that is the basic purpose of pursuing these efforts behind filing these applications and nudging different governments and IP offices to take a stand on them.
So definitely, so we really, because they have actually put in this amendment where they have included computer generated works, but that also creates a lot of ambiguity, in a lot of situations, like you said, like who actually should be the author in such situations. Owner in situations is very easy to presume, I guess, because of the work for hire doctrine, and basically I think the one who finances becomes the owner in a lot of situations.
Correct,
Authorship
correct.
is difficult to attribute. And so
Absolutely.
in that regards, we just the painting, that the Surya's painting also in such situations would have had, like, if AI was given the co-authorship, then that situation there would have been like 3 or 4 possibilities of authors. So it's very
Correct,
difficult.
correct. Correct, correct. And on the contrary, if we take a stand, if a government were to take a stand that anything that involves the use of artificial intelligence is not going to be given protection, are we not losing out on immense amount of innovation, eventually, which is here to assist us in our day-to-day lives? With time over the years, uh, the internet when it came in, then mobile phones when it came in, then smart mobiles, then now where we've reached with the kind of technology that we have around us. Uh, you know, uh, with each passing year, each passing decade, the job of technology or the purpose of technology really has been to make human lives easy
Easier.
and to assist us in doing something more efficiently uh, than what we were doing and how we were doing it before, right? So if that is the ultimate purpose, would it not be counterproductive to say we are not going to give any protection to anything that is generated by artificial intelligence simply because the old idea from the very 1800s of Copyright Act is to, or any other intellectual property law in the country, is to only reward human creation. So therefore, anything that involves artificial intelligence or anything that involves technology at all, we're going to not protect. So that brings me to another question. There are today so many examples. In fact, that would be a wrong way of talking about it. On the contrary, majority of, I think, applications that are getting filed for protection of, say, artistic works or musical works, they've all been created using technology. Who is
Yeah.
sitting with a pen and paper and drawing characters or creating content? Hardly anybody. So if I use, say, software like Adobe Photoshop, right? There's fair amount of artificial intelligence that is present in several of these kind of softwares as well, which are otherwise passive. But using filters, using so many different functions, they make use of AI to a limited extent and help you improve or add value to what you're already creating, right? So by that logic, even that image should be thrown out, right? And that image should also be refused. But the difference between anybody who truthfully discloses to the regulator
Yeah.
and somebody who suppresses this fact that they've extensively relied on technology is that the former application, even if it gets refused, at least the person that applied for it did what he or she is statutorily mandated to do, constitutionally mandated to do, to submit the correct factual position and details to the
Yes.
corporate office for the corporate office to exercise their.
Sir, I read about this. There was something similar to like that. University College London, I think there was a team. They
Mhm.
made like an application for certain soundtracks, and the record label that was financing it, they did not want to disclose it at all. That the AI was used to make these tracks, and so they would fake meetings with composers and musicians and everybody, and ultimately they did not disclose it. So I think that is actually promoting dishonesty on a lot of levels if we don't give protection.
Exactly, exactly. So that's another question that lawmakers need to start asking, because we're not talking of Star Trek kind of issues and things that it's purely academic. It'll come 10 years from now. Why
Yeah.
should we think about it? This is technology which has already entered our day-to-day lives, and we need to start. We should have thought about this yesterday. The next best time to think
It's
about it is
today.
now, and we need, at least the relevant stakeholders need to go back to the drawing board, reconsider whether the existing frameworks of intellectual property law or any other kind of laws that exist, are they adept enough to deal with the issues that today's technologies present? So I think that's the bottom line in my view.
Definitely, sir. And but sir, another question, don't you think that India has like a better stance on this than countries like I think US and Australia for that matter? They do not I mean an application like yours would have been outrightly been rejected in
So
US.
incidentally, in the US, we did receive a rejection.
Yeah.
And despite us arguing and clarifying, submitting clarifications and then legal submissions on the questions that the corporate office raised while they were substantively examining it, they eventually rejected it on a rather strange ground. They mentioned that while we appreciate that there has been human effort involved, but eventually the end product, we are unable to discern what part of it was contributed by a human, what part of it was contributed by a machine.
Oh,
And for that reason, we are going to refuse protection to this artistic work. So this is the stand that the US Copyright Office has taken in our application. That's the response we received. Of course, we are in the midst of filing a review against that, and we obviously wish to take it to its logical conclusion to get a definitive and final, view out of both the regulator, which is the Copyright Office, and then maybe consider taking it before courts and to see what guidance can the courts give, what kind of interpretation or views can the court
yeah.
present to the benefit of everybody involved in this. But yes, I do agree that at this point in time, there are certain systems that, for instance, I would take the example of the UK. Now, I had a chance, I had the privilege of participating, of being invited to participate in their public consultation that happened, specifically in the context of our experience with the Raga project, in getting our inputs on how they should treat artificial intelligence and the issues that it presents to copyright law. And what came out of that consultation is very interesting. One, they said we're not going to, or there's no requirement of amending the laws any further. By saying that, they also clarified that the existing copyright law in UK allows for computer-generated works to be protected, which means computer-generated works without limit. Even if there is no human being involved, it will still be rendered protection under the UK law.
The protection will be attributed to a human in the end.
No, so right now we're not talking about attribution. We're only talking about the simple question of if I disclose that this is something which is computer protected, and I file a case against somebody, because UK doesn't follow, many countries don't follow a system where they expect you to or allow you to file an application, then they examine it, and then they give you a registration certificate. It is a statutorily recognized right, and it is an automatic right to that extent. So in the UK, for instance, what you have to do is basically, if you've created something and it's original and it is something that you've created, or it's computer generated and you're the person essentially in control of the computer, and you've, as the Indian law puts it, causes it to be created, for instance. So in the UK, what you do is, if somebody, say, infringes your copyright, you go to a court. All you have to do is disclose that, look, this was generated by a computer. This is how I am the owner of this copyright, or how I am the author and the owner of this copyright. This has been entirely generated by a computer. That the court takes cognizance of that and then issues whatever necessary reliefs or whatever reliefs you've asked for in your favor once it is satisfied. So with this public consultation, two important things came out. One, they clarified to a certain extent that computer-generated works are already protected. So we don't need to amend the provisions any further to clarify that. So which led many of us to the conclusion that it obviously implies that anything which is autonomously created by an AI also is computer generated, falls in that definition, and therefore protected as far as the UK IP office is concerned. The second important thing that came out of that was whether the text and data on which the AI is trained, obviously it is all third-party data that, say, an application like Raga will get trained on millions of images before it reaches a level of competence or ability to be able to produce certain results. So the data set on which it is trained, technically I'm not paying any royalty to owners of the 1 million images, let's say, theoretically, that it is processed and trained on, right? So earlier in the UK, an exception used to exist for text and data mining, but that was largely only for non-commercial purposes and end users. So the second important thing that came out of this consultation was that UK IPO said, we will amend the law. The government will bring about an amendment. Actually, any industry that wishes to rely on any third-party data to train their AI program solutions on, they don't need to pay any kind of license fee. They won't be held liable for infringement of somebody else's works, merely because they are being trained on that data. The AI is being trained on that data. For argument's sake, philosophically, one line of thought on which this is based is that, take an artist's example. If I grew up in Paris, let's say, and I lived in a certain area and I was taught, I did my bachelor's and then my master's in fine arts. And when I walked from my home to my university, the kind of buildings, the kind of artwork, the kind of things I was exposed to, and then the kind of professors I had, and the kind of art that they exposed me to while teaching me fine art will prejudice uh, my style of painting eventually. Versus
Yeah.
if I'm say in Jaipur, right? My style of painting would probably be remarkably different from what it would be if I were in some other part, say Paris, as we were saying. So when we learn or we process paintings, images, other artistic works around us, not everything is in the public domain. Necessarily, a lot of it, a substantial amount of those things that we process and learn is basically the copyright of that belongs to somebody else, but we are not paying them license fee or royalty just to look at their paintings, say in an art gallery on a
Yeah.
day out with my professor to observe, learn, or say if I'm an architect on a day out. Now several pieces of architecture, newer buildings that have come up, in my city, those could be protected under various things, say designs law or maybe copyright or whatever it is. But that doesn't mean I'm paying them any fee just to look at the picture and to form an impression in my mind. And then based on whatever my mind learns, for me to develop my own style of art or architecture or whatever it may be, right? So, on the same logic, what people argued, a certain set of stakeholders argued, was that why should AI be made to, or owners of AI
Yeah.
that are putting them on data, be made to pay people any kind of license fee, any kind of royalty, or why should it be considered infringing use? As long as the output of what the AI produces, that output is completely different from what any of the million images that the AI processed while it was learning. As long as the output is very different from any one of the individual 1 million pieces that it processed, I don't think a case for infringement should be made out by this line of argument. And that's probably what also was accepted, or what UKIPO agreed with, and thus they decided to recommend on those lines for text and data mining to be included as an absolute exception in the case of AI programs, AI software.
If we just rely on works that are in public domain to train our AI, then all those works basically belong from the 20th century or before that, and so they have a certain level of prejudice or a certain style attached to them. So the diversity that you were talking about, somebody who is in Paris and who is very different from somebody who is in Jaipur and who's studying art, so that is going to be very different. And so basically art will not be very inclusive. If we just, the AI were to only rely on art which is in the public domain, it would not be very inclusive. It would not have talk about it would not be very inclusive of class, for example, or even some communities, for example, because they were not
Absolutely.
represented well in the art before. So that is another argument as to why copyrighted works should be under this fair use should be there for this
No,
purpose.
I agree with this. I absolutely agree with this. And I feel it's a very valid view. And thanks so much for pointing this out. But I do agree with you that for us to make it very inclusive, uh, we need to allow developers of AI get access to a very large data set, as diverse as you mentioned, as diverse and large as possible for AI to truly
I think
develop.
that is also the reason. So we time and again we hear about somebody black people getting sidelined by AI and disrespected
Yes,
by AI and
yes. So unfortunately, those are some of the consequences of training AI with a limited data set. Because
yeah.
then there's that principle of garbage in, garbage out. So what goes in is basically what will come out. And yes, that's very valid. Another counter argument that was presented during this consultation to the UK government, to the UK IPO, was that if you were to make commercial AI owners of commercial AI programs pay, it obviously wouldn't be feasible for them to one identify owners of 1 million different images, then be feasible for them to reach out to each of the 1 million People independently negotiate a license fee and then finally execute it. So a model on the lines of how collective rights management is done for any other kind of works or purpose, whether it's literary works or it's phonograms or it's whatever musical works or it's cinematography. So one suggestion was keep either a statutory license or keep a collective rights management thing where copyright owners can enroll themselves and that body becomes the body, the society that essentially issues licenses to AI, people who wish to get access to data, which otherwise is protected by copyright belonging to some person, XYZ person. And then for those societies to issue a single window, single kind of license, and then for them to equitably distribute the license fee that they've collected amongst the different people who've registered as members. So that was one alternate model that was suggested to the UK IPO, but of course, eventually it ended up deciding that or recommending that the law should be amended to make this an absolute exception. But we'll see. I think things will be more clear when the text of the amendment is actually out and we are actually able to see what the bill says that amends that relevant provision. And it'll make it more clear as to what they finally decided on.
Definitely, sir. And it needs to address, even in the context of India, it needs to address both practical implication-based questions and also academic and jurisprudential questions, because copyright law is, I think it is more towards the creative side, and that is why it is, the only law which has an element of moral rights attached to it. So we cannot, skip the jurisprudential aspect of the discussion. And in that light, sir, personally, what do you feel Indian IP regime for the purpose of AI should be like? Because there are basically 4 solutions being proposed. I mean, to give AI sole authorship, or to give co-authorship, or to make the person who causes the work to be created as the sole author, or like the public domain argument, and also lately the sui generis one. So where are you tilted at?
So, to be honest, my opinion doesn't matter. My job was to, or as I perceive myself, my job was really to spark this debate, and then it's for individual countries and their governments and other responsible authorities, etc., to take a stand and eventually decide which way they're going to do. They're going to go one way or the other. But I definitely feel there shouldn't be any debate on, or there shouldn't be much debate on whether AI generated work should be protected. I feel, of course, it should definitely be protected. The second thing that comes to my mind, if I were to be asked or to opine on which way it should go, the ultimate objective in fact, the ultimate objective of copyright law has always been to protect human creativity. It should remain that way. It should continue to protect human creativity, because machines, I'm not going to the debate. I don't wish to get into the debate of whether they are sentient, not sentient. I think that's a futile debate to have at this stage, at least in the context of IP rights, what we are having now. The question to really address is whether it should be an AI-generated or AI-assisted work, whether it should be given the same scope and duration of protection, the same right, kept at the same pedestal as a human author or a human creation. I would be inclined to answer in the negative. I would say it should definitely be kept at a pedestal lower. Now, whether it is a shorter right or it is a narrower right, or there are more exceptions to it, there are dozens of ways of keeping it at a lower pedestal, simply to ensure that somebody who's genuinely talented and is able to create something with his own hands should not feel disincentivized. Otherwise, we will eventually start losing out on arts, on creativity. And art, when we talk about art, I think obviously copyright goes far beyond art. We're talking about music, we're talking about literary works, we're talking about software, we're talking about all kinds of things. So the idea is that eventually the human author should remain incentivized to keep creating. People who are talented as a consequence of their training, of their hard work, of natural talent that they were born with, should continue to be rewarded, and technology assisted things where another human being makes use of technology and creates something which is at the same level of quality or creativity as with their own hands or by exercise of their. That's the only other point that I'd like to make. So on these two things, I think protecting AI generated works is definitely a yes for me. Keeping these two categories of rights at the same pedestal is something that I would not wish to recommend or be in favor of. So that kind of summarizes my
And so,
position.
would you also like a bifurcation in AI assisted work and AI generated work?
See, I'm not sure. Of course, at some point in time, AI would become so advanced that we'd be able to have a definition that works practically. Otherwise, anything where there's too much of subjectivity, it ends up going around in legal circles. And there are divergent views that come out, and there's no finality in how it is to be judged. So in India, also say a High Court in Odisha may end up taking a different view. High Court in Delhi,
Yeah.
High Court in Bombay may end up taking a different view. If there is a matter in which there is too much of subjectivity, I think those matters are not the best kind of matters to really be discussed at the very nascent stage of something, a debate or some issues that we are at. I think as technology develops, we'll probably get more objective parameters to really base classification on whether this is assistance, this is entirely this, and also to retain proof. Eventually, regulators, copyright offices, IP offices around the world should also or may also end up asking for proof. How was this only assisted? So let's say, hypothetically, tomorrow the definition of assistance becomes anything where the human being uh, provided some input, right, beyond whatever, right, will be declared. Anything where there was no human input will be autonomously generated, right, or generative, right? If we start off with that simple distinction, autonomously upon a single prompt, and then multiple prompts, more than one prompt by a human being is, say, assistive, right? Then for me to claim, right, who has seen whether what was created by Raga was autonomously created or whether it was created by me? Now, there should also be at some point in time proof or evidence that IP offices should demand, saying, tell us either, for instance, I mean, I'm just now talking off the top of my head, it may not be practical what I'm suggesting, but say one solution could be that provide us with a recording, screen recording of the point exactly when it was produced. If it took a lot of time, then there may be many works that don't take a few seconds. There are many works that are consequence of months and months of efforts. Movies, for instance, 3 hour long movies. The special effects that have been created are generated with the assistance of AI, right? There could be, you can't really capture it, but I'm saying, perhaps at some stage the regulators might start asking for evidence of somebody having assisted, or rather the other way around, of the AI assisted and the human being having provided some inputs, because everything else would simply be generated with a single prompt by, as we are seeing in the case of DALI or GPT-3, all you have to do is give it a single prompt in terms of a single sentence.
Yeah, and it will just
ask prompt GPT-3 and say, okay, what do you think of India's geopolitical positioning in the Asia Pacific region? And it will generate probably 500 words of what it feels its views are. Feels as in, well, not really feeling, but basically what GPT-3 is able to compile or generate or presume is the correct answer, based on whatever factors it has been trained on. So same with art, with how DALI and other tools are working. Throw a few keywords at it, single prompt, and it generates something. It doesn't require, but beyond the single prompt to turn something on, there are no further prompts that are required by a human being. So those kind of works could easily become generated works. The other could become assistive works. So that could be one way of looking at this thing. Speaking of which, I'm not sure if you followed, but it's already started happening. I saw saw an article on the internet, which was published by New York Times, where an AI generated artwork apparently has won a art competition, and artists who participated are not very happy with the outcome.
Oh,
So
that is
another
actually
point,
funny.
yes. So another point, just to make us realize that this isn't far-fetched. It's something that is already part of our lives, and it's high time that we need to start thinking what and how our laws need to be adapted to meet these new challenges that technologies are presenting.
And sir,
So
along with
yes.
laws, there need to be certain infrastructural changes also to be made to the IP offices to understand, what kind of work the AI has been trained on. And so, do you have any infrastructural changes in your mind that India should make
Um,
the IP
I
office?
think I think I'll mention there is a very interesting role that a relatively new body which comes under the government of India is playing. It's called the Capacity Building Commission,
Okay.
which was born out of the Mission Karamyogi, uh, which the Prime Minister announced. And what the Capacity Building Commission is doing, and to the best of my understanding, I'm not really an authority on this, on skill development or capability, capacity building, etc. But what I understand is historically this is the first time in India there is a dedicated body and a dedicated set of experts that are looking into how we're going to upskill our civil servants. How do we upskill our judiciary? How do we upskill the people who are sitting in these kind of roles? Examiner of copyright,
Yeah.
controller of patents, who eventually deciding whether something should be rendered protection under a particular statute or not. So I think infrastructurally changes can keep happening. You can always have better offices. You can have more technology that you can purchase, and But I feel before that the solution really lies in focusing on training our civil servants, our judiciary, and other people, even lawyers, uh, ensuring that their upskilling journey is fruitful and practical to the extent that we're able to appreciate the challenges that industries are facing. Only then will we be able to formulate an argument or render advice, and only then, based on whatever argument or application we create or whatever strategy we devise, and then we present it before a regulator or a court and we represent our client's case. Will the regulator or the court eventually then understand? So each set of stakeholders, right from government, judiciary to lawyers and others, need to be upskilled in that. And I think the Capacity Building Commission has already started doing a phenomenal job out of it. So I think upskilling is what I would really wish to focus on in terms of how I feel we could start preparing ourselves for what kind of challenges these technologies are going to present.
Definitely, sir. These because at every stage it's not possible to summon experts to understand certain situations. So personally also they have to be they I think they have to come at like par in understanding certain things about IP law, like for example, the definition of the term person also under the act. So it also needs to be at par with the patent law as well. Like there has to be some kind of consensus on certain basic things. Likewise, in all the stakeholders, there also needs to be some basic training and some basic knowledge which is on consensus among all parties. So
Correct. At the very beginning of of things, of where we are at, and of where even countries are at in terms of developing a policy, and then eventually translating that into tangent legislative changes. I agree with you, but I feel a lot of people, for instance, academicians have a very different view to the fact they, for instance, outrightly
yeah,
believe that any.
their basic argument is so that because IP laws, copyright in particular, has two basic principles. The first is aesthetic neutrality, and the second is technological neutrality. So it should at all times follow, these two principles, and it should not matter. The basic thing is that earlier we used to focus on authors, and now maybe the copyright law will shift more into the work, basically the final outcome. It will be more.
Correct, correct. Absolutely, absolutely. So I think we could probably have a more diverse set of people in whenever next you wish to have an interview on the same topic, next one in the series. And it'll be interesting to have somebody else present counter views, and then for us to debate and tell them our side of the story, and then for them to present their side of the story, and hopefully agree on certain things or agree on a third approach that could take care of both sides' concerns, and maybe present the balance that is required to be presented to take care of the problems, the issues that
I
we're
think,
currently
sir,
facing.
even though there are people who have various different sets of, arguments, I think, but there is one thing that they all agree on is that, like you said, that AI generated works have to be given some, level of protection. I think
Absolutely.
everybody will agree on that.
Absolutely, but
I read an argument, for example, like you said, that, you're not very artistic. So, if I give you like 20 seconds and I give the AI 20 seconds and ask you to, make a man, you'll probably make like a stick figure or something.
Correct,
and,
correct.
In the exact same time, the AI will make something as complicated as like the next Rembrandt, or, something like that, which will be sold for like millions at auctions. Like,
Absolutely. Absolutely, no, I agree with you. So this is a very important difference to bear in mind, and at the same time make ourselves be reminded of the fact that eventually the AI is also being developed by a human being.
Yeah.
We also need to take care of those people who are developing these solutions, these technologies, which eventually are making our lives easier. So no, with that, I think we had a great discussion.
And on that, lastly, sir, I just want to understand that they say that, like you said, that we need to incentivize people to, invest in AI and to make AIs. Don't you think that copyright law and patent law also, in some situations, they protect the underlying code for the AI? So further protection is, I think, it's the debate is philosophical then. Like,
I understand, but if there is something useful that is being generated out of something which is already protected, the question is if something new gets conceived and created and fixed in a tangible medium or plane. For instance, anything that Raghav produces, for instance, anything that Dabas produces, if it's of some utility, if it's the consequence of somebody's efforts, why should it be in the public domain? Why should it not be protected? Even if it means protecting it at a lesser degree or lesser pedestal than what a human inventor's invention or a human artist's painting or a human musician's musical composition should be protected at, but enough to keep the those that have created the data or have contributed in training the AI, and those that have coded the AI, the framework, the algorithm, for them to remain incentivized to keep creating more such technology, right? So that's, I think that it all boils down to this at the end of the day.
Lastly, I know this is also not a practical question, but like, I was confused because, you commissioned Raghav, and then you also gave Raghav the photograph, based on which, the painting was to be generated.
Correct.
Do you think if there was like a third party, which was, for example, you tell me to click a picture, Mahak, click a picture, and we'll feed it into Raghav and see, how Raghav changes it into a painting. Then who would have like been the author? Owner, of course, would have been you.
Correct.
Author, who would have been Mr. Raghav Gupta, who actually made the AI, or you, or I?
Correct. So the reason for for our in all our test applications, the reason why we included myself as the author was not because I programmed it. Obviously, Mr. Raghav Gupta programmed it. We included me as the second author because I contributed the original photograph, right? So in that case, of course, it'll be very interesting to have this debate and till we reach a conclusion, till somebody amends their law and you know basically clarifies on what in their country, in their jurisdiction, what it's going to be like. I think this can very well remain one of the more important key questions that in such a situation, what is it going to be like? Are we totally going to ignore the guy that created the program just because he didn't prompt the program at the relevant point in time that it produced the work which was applied for? Should it only be the program and the owner of the program along with the person that provided the content input, or what should it be? So all these are obviously very important questions. And as is clear from the applications that we filed, we had to basically base it on some argument, some base case. And in our base case, we have presumed authorship to be for the human, both for providing the original photograph as well as for providing the prompt, and for excluding Mr. Raghav Gupta as the developer of that solution is basically because while they contributed, he and his team contributed in training, both developing the solution and then selecting the data and ensuring it gets trained on that data set. They didn't provide the prompt at the relevant point in time, which led to Raghav producing that picture, that output. So we based it on who would be the human who would prompt it at the time it produces that image.
So basically the user of the application.
The user or the operator, but legitimate user. So assuming a country adopts this position tomorrow, right? So, as diverse as different countries' laws are today, one could expect each country to also adopt a diverse position or approach as regards how they're going to treat AI-generated works or AI-generated, inventions, etc. So assuming one country agrees with this view, one exception to that could be I could be operating a pirated version of or an unlicensed version of Raghav. Will I still be entitled to file for copyright? Because I cannot be said to be legitimately in control. Ankit Sahni in this example was legitimately in control because he acquired the title or the ownership. That was the simplest way to argue. To complicate it further, we could have simply acquired a license from them. And then based on the license, we could have said while it was operating, I had a legitimate license to operate it. But then there would have been further questions from the IP office. Another issue that did the terms of the license entitle you to claim ownership over whatever gets produced while you're right? So if you remember back in the day, there used to be a program for amateur music producers and DJs called Fruity Loops. Right, so Fruity Loops was so this was in 90s when I was in school, right? So back then we used to have a program called Fruity Loops, and what Fruity Loops did was in the terms of license, basically Fruity Loops said, look, we're giving you the sounds, the samples, and everything, but you're going to retain copyright over whatever soundtrack you produce from it. So the terms of the license clarified. But if the terms of the license were not to clarify, that could be one further complication or issue that would arise in such a case, or in a case where I do not have access to it legitimately. If I'm accessing somebody else's copy, or if I'm using a pirated copy of a software that allows me to do it, will I still be entitled to claim ownership or not? That would also be an important question for governments to consider while they're considering this.
Yeah.
I think in conclusion, I think lots of open-ended questions, but it's good. I like questions because once you have questions, then there's bound to be answers. So the first step towards things, towards
asking the questions,
change is to raise questions, and that's basically what we've been trying to do with this experiment. It was a pleasure. Thank you so much for inviting me.
Thank you so much for being here, sir. Thank you so much.